This is Learning Unit 4. This is Role Morality. Now, those of you doing the supplementary, aggregate or special exams, or those of you who have gone through the previous study guide, do not be scared. This might look like new work. It's not. It is old work from the previous study guide being reshuffled and having a new title. So do not be scared. I will take you through it and you will realize that we actually have done this in the previous study guide. So on page 43, you can read through that. What is important is the bottom. And you will see once again on the left-hand side where I have these catchwords, the adversarial system. Nice question to be asked for 3 marks. And it is shocking because it was asked at the end of last year. What is the adversarial legal system? And that is the system we have in South Africa. And then you get students who get naught for that. It is unacceptable. You have been taught this in civil law, in civil procedure, criminal procedure. It's all over. The adversarial legal system means there's an independent judge or magistrate that sits and adjudicates while 2 parties fight against each other. The plaintiff and the defendant, the accused and the state. So it is just that there are 3 parties in our legal system. And we have adversarial system. You've got an inquisitorial system, that is in France. That is where the judge actively asks questions and become one of the parties investigating. We do not have that. We have an inquisitorial system, and that is where the judge listens to the people in front of him or her and then makes a decision. So nice question for 3 marks, and every exam paper has one question with sub-questions of 5 marks, 3 marks, 2 marks, 5 marks. So this, what is an adversarial system, is a nice one. If we turn over to page 44, there we now come to the detail of the role differentiated approach. Remember, I referred to it earlier under the rule-based approach and said that the people follow the rules and then they cross-examine very strongly in court cases, and when they are criticized they say, no, but I'm just playing a role. I'm an actor, I'm not the same person at home, in church, in communities that I serve, what I am in court, because in court I'm an actor, I play a part and I do my job. So it starts there at the bottom of page 44, and this is a nice separate question to ask for 10 marks to discuss the role differentiated approach. Or we can ask, do you agree with the role differentiated approach or disagree, and then you must give us the information. So that is on page 44, 45 and 46. And please make sure that, in order to make sure that you get all the marks, refer to Markovic. What did Markovic say? You will see on the left-hand side, I've given you catchwords. And Wasserstrom, what did he say? It will just, if you can mention their names, already you have 2 marks. What did they say? Another 2 marks. So explain what is role differentiation, that it is playing a part like an actor on stage. There's a difference between your professional life and your personal life with your family, and then give a little what does Markovic say, what does Wasserstrom say, and make sure you get 10 out of 10. Then on page 47, there we mention an article written by my previous colleague, Dr. Freddie Mnyongane, and it's very interesting. Remember, it is not prescribed, but if you are interested in the topic, go and read a little bit on what is transformative constitutionalism, multiculturalism. It is extremely interesting, and we give you the full particulars where you can find the articles on that page. Then on page 48, now you will once again see those of you doing the aggregate or supplementary or special exam. Once again, the old study material. So on page 48, and we ask this question I think nearly every time. The duty of a lawyer in an ex parte application. It is on page 48. First of all, what is an ex parte application? And I'm sure the majority, I will go as far as to say that 99% of you must have done civil procedure. And in civil procedure, you learn about motion proceedings and ex parte applications. So first of all, we want you to tell us that in an ex parte application, there is no defendant. It is just the advocate or attorney appearing for this party. In other words, there's a much bigger duty on that person to be truthful, not to mislead the court, to put all the facts on the table, even facts that will go against the client, because there's no other party. Remember, when there's a plaintiff and a defendant, then by arguing this, some things can come to light. But in an ex parte application, it is one party only. So make sure, question of 3 marks. Page 49, question of 2-3 marks. Are lawyers allowed to talk to the media? And it is extremely relevant in the days that we live now, where we've got all these high-profile cases. If you could just think back about the Oscar Pistorius case. Are lawyers allowed to talk to the media? Yes or no, and under what circumstances? And you'll find that on page 49. Then on page 49 as well, to the bottom, where we speak of witnesses. And this question has been asked also previously. It is also of the old work, in the old book. But for some or other reason, students do not read this, or they miss it. So mark it on the top of page 50. It is important. And the question could be, can a lawyer make defamatory statements in court? Okay, to break defamatory down. Can they be rude? Can a lady in court be called a slut or a hooker or a whore or whatever? I can't even pronounce the words. But can the advocate under cross-examination refer to her in that terms? And you will find the answer on the top of page 50. You're only allowed to make defamatory or slanderous comments in court if it is taking your case forward. But there is a little bit of privilege in a court case that you can go that little bit further than ordinary citizens can, within limits. Within limits. So we like asking that question because this is ethics. And you need to know what you can and what you cannot do one day in court. So that can be a 5-mark question. And then ethics of care, that links with what I've mentioned about feminism, that there need to be a little bit of more of a softness in our legal system. And then African communitarian lawyering. That is where customary law will put on par with common law. There are already indigenous courts. It's not that common as the Constitution prescribes. So we've added this to make you aware of this. In future it might become more and more important. So this is actually not a long module. There's a few things that we can ask that I have highlighted. If you know that, you will be fine for the exams. So this is then the end of Learning Unit 4. And this is also the end of my boring voice. So I'm going to end now. Please, you are welcome to contact me at any time with any question before the exams. I cannot help you after the exams. Those of you writing the supplementary aggregate or special exams, please pass this time. You will see that even though it is a new study guide, the work has basically only been shifted around and the content are still the same. Listen to every comment that I made, and there's no reason why you should not just pass, but all get a distinction for this subject. So I'm saying goodbye and good luck. The next learning unit will be done by Dr. Maureen Mswela. Thank you. Bye-bye.